first business at hand. Hearing that the Fayette County case that was kind of tied up in all this has been dismissed. Obviously, the state, if they choose to, and Fayette County can take it to grand jury, but that's their business. As of today, at this moment, it's closed. Given the fact that that they have crossed Fifth Amendment rights, the state cannot go forward under any scenario that I can imagine, and Mr. Shepard is saying the same thing. Therefore, I'm constrained to grant the two processes on these two cases. Do they live outside of the county? Do they live in Fayette, or where do they live? I guess that's what I need to ask.
I live in McDonough.
Okay.
In Henry County, and he lives here in Gresham.
Yes,
Okay.
my client does live here.
Okay, so y'all are not residing under the same roof at this
No.
time? Okay. And are y'all anticipating residing under the same roof in the immediate future?
We're going through, counseling,
Yes.
family counseling.
Okay, that sounds fine.
Yeah.
So you're not the first couple that's had to do that, and you certainly won't be the last, so. Okay, well, all I want to do is just be very careful and make certain that if there's, like I just had this vision of like, if there was a divorce proceeding and there was contact governed by that, I just wanted to be very careful and say, this covers what's going on here in this court with these cases. There was obviously some Fayette County stuff that probably had some conditions. If there was a divorce, those would have conditions. So you just need to be extremely careful of your landscape and make certain that there's not some other court with some other order that I'm unaware of that controls y'all's contact with each other. I just wanted to be very careful.
And Your Honor, they are aware of the divorce side of that because that's what they started and then ended up removing that also. So
Okay.
they've been through a lot of it and are kind of undoing all those pieces.
Okay, that makes sense. Okay, well then I've signed the 2-0 process. Let's check her other case. Have you found it? I need to go check.
Germany, you're still under oath, correct?
Yes, sir.
Right. So you're also the named victim in the State versus Hilton, Germany, which is 23 SR 1741. Is that correct?
Yes.
And that's a violation of a family violence order wherein he's accused of violating his bond conditions and coming back around you, correct?
Yes.
All right, if I were to call you to testify against Mr. Germany in that case, would you testify against Mr. Germany, or would you choose to take the Fifth Amendment privilege and or the spousal privilege and not testify against him?
Not testified.
Okay. You understand that in doing so, that case would also be dismissed as the family violence case?
Yes.
And that's what you want to happen?
Yes.
So Judge, with her saying that, we'll just consent to null pros on that one too.
Okay.
Be done with all of them.
And then that will leave this obstruction charge, which is has nothing to do with us. It's a felony. I'm just trying to figure out. Oh, he's got a totally different attorney on that one. Quinn, Quinn Johnson.
Your Honor, not only is he not familiar with the case, he doesn't know who Quinn Johnson is.
Hilton, Jerome, Germany. I'm printing the warrant now so we can. Okay, well, let's go back off record then and look at documents.
We knew he had the.
Yeah, he's got a felony obstruction in Henry.
Yeah.
What's that?
Y'all want more copies later? April 27th, 23. I mean, obviously the booking photo, it says there's 3 counts.
That's something happened at Walmart.
Just 3 counts of obstruction. You can show it to him. Like I said, I just want, my goal when we finish here is just for everybody to gather. We have everything. We've gathered up all the documents. Maybe it's clear, but let me do one more search for her. Because I've now dealt with his 2 misdemeanors. Let's go do a search for her.
No, it's here. She tried to restrain order and it was dismissed. But
But we
it's
still have the trespassing.
yeah, that's the trespassing.
Yeah, Your Honor,
That's outside of
we
it.
still have the trespassing, which is still related with, that's dealing with, actually his mother. But technically that would be pending.
Yeah,
That's
in here, that's what just found it.
Yeah, that one's right here. That's the one I said is not.
Right, yeah, I don't think that's.
So that's just a rain on. So here it is, 23 SR 1632, it's not a rain. So I need a rain, it's criminal interference. Possession, family, okay, so criminal trespass, family violence. So, okay, so Erica, if you'll pick any date, any trial date of your preference for 23 SR 1632. That will close, that'll move that one to a date, and you are the attorney record on that one, correct?
Your Honor, he was arrested at the time and has since bonded out. So I don't know if we need to take any action on it. He says that they told him they were gonna dismiss it, but obviously it wasn't dismissed in the system.
No,
But he was bonded out, so there's really
it's
nothing.
not mine, so that's y'all's copies to keep, so. Okay,
That was not our problem.
yeah,
Is it possible that they just they arrested him on one warrant and then the other 2 came out?
That might be what it is.
yeah. Okay, everybody ready to go back on record? All right, everybody, let's go back on record. All right, the Germanys had several each of them had multiple moving parts, and we just wanted to be very careful, so we went off record and talked about a lot of stuff. Here's what we know for certain. Mr. Germany's 2 cases in this court are now resolved. We'll sign that null pros on the second one because it was also tied to Miss Germany. Miss Germany also has 2 cases. I dismissed the one that's on the case today, the null pros on 23 SR 1414. But as Mr. Shepard pointed out, she also has 23 SR 1632. Mr. McCullough is also the attorney of record. We are arraigning her on that case today. And before they leave, they will sign a reset notice for a jury trial date. We will circle back to that one on another date. There is a felony pending upstairs for Mr. Germany. It has nothing to do with me. I simply brought it up out of courtesy to everyone here to make certain that there's no confusion. It's felony obstruction from Walmart last April. It has not been indicted or accused to the best of my understanding, and they are all 3 felony charges. Mr. Dutton now has copies of those warrants, and it says that he has an attorney named Quinn Johnson, might be Public Defender's Office, I don't know. I don't know Quinn Johnson, nor does anyone else here recognize that name. So usually I can go, oh yeah, that's the Public Defender's Office, but not that name. All right, does anybody else need to put anything on the record as far as the
Your Honor, there is also a felony case pending for Mr. Germany in Henry County. Again, not connected to anything here. He's aware of it, has attorneys for it. I just wanted to
Yes.
put it on the record here that this has nothing to do with those cases, that still has to be separately resolved.
Yeah, and y'all had mentioned that one earlier, so. All right, I will print a blank dog process for you, Mr. Shepherd.
Thank you, Judge.
And that way we can just circle this up and be done. I'm with you, I'm ready to just be done.
Yep.
So as far as I'm concerned, y'all need to go and live in peace, go to your counseling. And I'll see you back here with Mr. McCullough. You're finished with me. Y'all go get your stuff done, get your lives back in order, and y'all go live peacefully, okay?
All right, thank you.
All right, y'all are free to go. Keep in contact with your attorneys. You both have very good attorneys. You need to listen to what they tell you to do and follow their instructions.
Thank you.
All right, let's get that off us for a minute. Yes. All right, and Mr. Evans, have you had all the time that you need to speak with your attorney about all aspects of your case?
Yes, I am.
Are you satisfied with the job your attorney has done on your behalf?
Yes, I am.
Do you understand that you have the right to a jury trial on this case?
Yes.
And that by entering this plea, there will be no trial and this case will be closed. Is that what you want to do in your case, Mr. Evans?
Yes, sir.
All right. Do you have any questions for me about anything, no matter how minor, before I pivot to Mr. Morton with my next questions?
No.
All right. Mr. Morton, do you stipulate that there is a factual basis to support this disorderly conduct plea from January 11th, 2024 here in Spalding County?
Yes, so stipulated, Your Honor.
Mr. Evans, do you wish to enter a guilty plea to that disorderly conduct charge?
Yes, sir.
All right. I'm going to find between the attorney's stipulations, the factual basis, combined with the defendant's request to enter the guilty plea, that there's enough for me to take this plea. I'm going to find that Mr. Evans is knowingly, voluntarily, and intelligently waiving his rights in entering this plea. I've reviewed the recommendation and I will follow it. Mr. Morton, the floor is yours if you would like it.
Simply, Your Honor, I've known Mr. Evans for 26 years or so. We played softball, raising money for World Services and so forth. This was a family incident. It was very unfortunate, and I appreciate the efforts for Mr. Shepherd in working this out, and that they have resolved this. The no violent contact is with his wife and child, and we just asked the court to accept the recommendation.
All right, which I certainly will.
And Judge, I'll just add that we have been in contact with the victim in this, and this is her desire that it be a reduced charge and the no violent contact so that her husband can come home and they can be a family again. So that's why we've decided for the reduction you got in front of you today.
Okay, perfect. Thank you, thank you. All right, Mr. Evans, do you have any questions for me that I can answer before I sentence?
No, sir.
All right, you ready?
Yes, sir.
All right, Terry Evans, 24 SR 0091 from January 11th of 2024. Count one, disorderly conduct. I'm going to find you guilty. It's 12 months probation, 590 is your fine. Count two is dismissed. You may work off your fine with community service work, show your valid license to sentence enforcement. No alcohol, illegal drugs, or hemp products need to be tested for those. Fourth Amendment waiver, $50 per month supervision fee, $25 intake fee. This sentence shall be consecutive to any current sentence you may be on at this time. 20 hours of community service work at no less than 6 hours per week. No alcohol, we already covered that. No violent contact with Michaelan Pitts or Jonathan Evans. And that is the sentence of the court. You have 30 days from today if you wish to appeal this decision, and you have 12 months from today if you wish to use your habeas rights. Are there any questions, Mr. Evans, that I can answer for you about anything before you and I part ways?
No, sir.
All right. You've already filled out your probation acknowledgement form, so what I'm going to do is just have you have a seat out in the gallery. I've got a few things I need Director Matthews to do, but as soon as she gets finished, she'll come down and speak with you, give you your last set of instructions, and send you on your way.
Okay.
And Mr. Morton, you're welcome to stay or go as you please.
Thank you, Your Honor.
All right, thank you. Okay, all right, let's jump in. I am going to point out that I did ask you all to turn your phones off, and I've noticed everybody staring at your lap on the back row back there. So I'm wondering how in the world you're staring at your lap when your phones are supposed to be off, so I'm going to give you one more shot to turn those off. All right, what I'm going to do at this time is run my way through. All right, so we dealt with the Germanys. All right, let's do Mr. Litton's. Or unless y'all have a preference. Mr. Shepherd, do y'all have a preference on anything else?
That's good. We can just kind of work through whatever we got.
We turned in our arraignment paperwork.
Okay. All right, Mr. Litton, I'm going to send you an unmute request. If you'll approve that, please. Perfect. All right, Mr. Litton, you are here with permission to report virtually on 22 SR 1656. I'm actually going to swear Director Matthews in separately, so give me just a second on that. Director Matthews, I'm going to swear you in on all testimony you're going to give today. Do you solemnly swear or affirm, Director Matthews, that on all cases that you will testify to today, that you will tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, you're sworn. I will not swear you in again. Mr. Litton, do you have the ability to turn on your camera at this time?
Yes. There it goes.
There we go. I see you. All right, raise your right hand for me. Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right. Mr. Litton, if you'll state your full name for me.
Corey Scott Litton.
And Mr. Litton, is it acceptable to you, is it okay with you that we're having this hearing over this video conference system?
Yes.
All right, so Mr. Litton is virtual. Mr. Litton, where do you reside?
I live in Ohio.
Okay, so, and that's why you're virtual.
Yes, sir.
So here's what we're about to do. If you ever at any moment can't see or hear to your own satisfaction, just wave your hands frantically or get my attention and we'll stop and repeat it, okay?
Okay.
All right. Mr. Litton, do you understand that you're here today because your sentence enforcement supervisor has filed paperwork alleging that you're out of compliance with your probation conditions?
Yes, sir.
Do you understand that you have the right to have an attorney represent you?
Yes, sir.
And you are here today representing yourself. Is that what you want to do?
Yes.
Okay. I'm going to let Director Matthews read out what the allegations are, and she's also going to read out what the state's recommendation is that I followed. And then I'll ask you if you admit to the violations, and then I'm going to ask you if that recommendation is acceptable. At that time, I will decide if that's the appropriate recommendation. But I'm going to tell you I've already looked at it. So, all right, Director Matthews, the floor is yours.
Judge, on 22 SR 1656, the defendant is alleged to have violated the terms and conditions of probation in the following. The defendant failed to complete community service hours as directed, having turned in 0 of the 20 court-ordered hours. The defendants failed to provide proof of attending and completing the Family Violence Intervention Program by the deadline of December 31st, 2023, as ordered by the court. The recommendation on this case is for him to report to probation as directed, payments of $65 biweekly, community service at 8 hours a week, 0 tolerance for the duration of active probation, proof of enrollment in the Family Violence Intervention Program would be due within 30 days for him to go weekly without interruption. His next report date would be by phone on March 20th between the hours of 9 and noon.
All right, 2 questions. First question is, do you admit to the violations, Mr. Litton?
Yes, sir.
And is that recommendation acceptable?
What do you, so the $65, what was that for?
That's to get you caught up on your arrearage.
Okay. Okay.
Yeah, because you're behind. So to get you caught up. Just remember, if you're not able to pay it, if you're not able to pay the fine, you can work your fine off with community service work. If you're not able to pay your supervision fees, you can ask that those be waived. There's hoops to jump through for both of those, but they are available to you.
Okay.
All right, is that recommendation acceptable?
Yes.
All right, I agree. I think it's a good, solid nudge to get you back in place. I also think it's kinder and gentler than what I would have come up with if I was left to my own devices. So I'm just telling you right now that you need to get this thing finished, because if we have to circle back to this, I'm very likely going to find that you need to buy a plane ticket and come down here. Which you don't.
That one.
Yeah, I'm just telling you that we're circling the edge of that option. And I know you don't want to do it, but I will not hesitate to have you do that.
Okay.
All right, so please go get your case. I'm going to put a note here that says you were virtual. Do you want Ms. Leach to do a transcript? Okay, no, we're not worried about that. All right, perfect. All right, do you have any questions for me?
I do not.
All right, report is directed. Get your case closed, okay?
Alrighty.
Thank you.
Thank you.
All right, that's Mr. Litton. Next case is the show cause on Pierce. And I guess we need to talk to Mr. Kleiner in a second too, so. All right, Ms. Pierce, you there? Mr. Litton?
Yes,
Yeah, good, Mr. Litton's got it. Ms. Pierce, do you have the ability to turn your camera on for me?
I do.
Perfect, okay. Ms. Pierce, will you please raise your right hand for me? Do you solemnly swear or affirm the testimony you're about to give in this matter will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
All right, so this is the show cause petition on Ashley Pierce. Ms. Pierce, there's not an allegation that you have violated your probation in any way. It's just that at this time, I'm required to have a hearing to determine whether to continue your supervision or to release you. And do you understand that's the purpose of this hearing?
Yes, sir.
All right. And so what I'm going to do is, at this time, Director Matthews has already been sworn. And so I'm going to actually hear from her about the status of your case, kind of how you've been doing, and what do we have left.
Yes, sir. Thank you.
All right, go ahead.
Judge, on 21 SR 1540, Ms. Pierce was sentenced on 3 charges of obstruction on April 18th of 2022. This is a 36-month case. She has the option to go into non-report after being on active probation for 24 months. She'll be eligible for the non-report option on April 18th of 2024. She was not ordered any conditions on probation, just to report and pay. She's been currently on for 696 days. She's never missed an appointment, and her case is paid in full for the 24 months. No revocations have occurred.
Wow. Does it say that recommendation?
I didn't discuss it.
How long has she been on?
696 days. April 18th will be her 24-month.
It's 36 total?
Yes, sir.
So
No violation?
I'd be giving her a 30-day benefit if I were to do that.
I'm fine with that.
Okay. All right. I'm gonna
Reward
go-
somebody doing something right.
Yeah, so. Yeah. All right, Ms. Pierce, we always love rewarding good choices. And, what Director Matthews in a nutshell has just testified to is that you've been an exemplary probationer. And so we're gonna reward that. So what I'm gonna do is, I'm gonna, what's her next report date? I'll just make that one. Do you need to, you're okay?
We just need one more report. So she online reports, Judge.
Okay.
And so as long as she reports after April 1st or on or before April 15th, then that would be her last report. And then we would close her case with the court's permission on April 18th.
Okay, all right, so what I'm gonna do is, your case, when you're finished with this, is set to go to what's called non-report, Ms. Pierce, meaning you would still be on probation, but you wouldn't know it because you wouldn't have to report, but if you caught a new charge, I would take a warrant. What the state, and I just discussed, rather quickly, but now I'm unpacking for you, is the idea that what if I converted that from non-report to terminate? To reward good behavior, and that would cut you loose from me a good year earlier. And so that's what I'm gonna do. I'm gonna go ahead and say, just, check in on your last, you got one more report date. That'll get you to the end. That'll let you have a debrief with the sentence enforcement team, make sure all the boxes are checked and everything's finished. And then when your April, non-report date gets here, instead of non-report, it'll be terminate.
Yes, sir. Thank you so much.
Is that acceptable to you?
Yes.
Okay, so, do you want me to put, I'll just initial here, which I'll be terminated upon. You're busy. Director Matthews has it totally under control. All right, I've signed the order that says it shall be terminated upon 24 months.
Sir, thank you. I really do appreciate that.
You're very welcome. Like I said, we are very thrilled with what you've done here. Great job, and we like rewarding, good behavior. So good job, Ms. Pierce.
Thank you.
All right, you are free to go, and like I said, you have one more check-in. So check in when you're supposed to, and then we'll get your case closed.
Yes, sir. Thank you so much.
Thank you.
You have a good day.
Thank you. All right, so right here, show cause, terminate on 24 months.
Thank you, I just want to confirm that.
Yes, sir.
Okay. Kathy, did you need to say anything?
I'm good, I was just confirming the number, Ms. Matthews.
Okay, so, all right, so now we've closed the Germanys, we've closed Lytton, Rapes is off. Anthony Taylor?
Yes.
All right, come on up, let's, John, have a chance to talk about that.
Yes. Speed on it.
All right, so come up to the podium, please. All right, if you'll please raise your right hand for me. You solemnly swear or affirm the testimony you're about to give in this matter be the truth, the whole truth, nothing but the truth, so help you God.
Yes, sir.
All right, take your hand down, state your full name for me.
Anthony Cortez Taylor.
All right, Ms. Taylor, you're here on 3 cases. 21 SR 2672, 21 SR 2673, and 21 SR 2675. I don't have that paperwork. Is it a revocation?
No, sir. It's his own motion.
Oh, okay. So it's a per se, self-represented motion for, what is it, Mr. Taylor, if I were to do what you want me to do today, what would I do?
Lower my fine, cause I just got out of prison February 20th.
Okay.
I did 27 months, off 2 years, and they got me, she got me reporting twice a week for $250 every time I report. And it was her idea, like, go and ask for a reduction, because, you know what I'm saying, you say too much, I can't pay it. I can't afford to pay it right now. I do have a job I start tomorrow down in renewals.
Renew?
Yeah, yes, sir. I got a job there, but they working 12 hours. I told her they working 12-hour shifts, and she want me to report every 2 weeks. So the only reason she got me reporting every 2 weeks, cause my fine so high, and I got a year to pay it off. So she told me to come and ask, can I get a reduction on it?
Yeah, that's the appropriate procedure. I don't know if I'm going to grant it, but you followed the right steps to get it.
Yes, sir.
All right, Mr. Shepard.
Yes, Judge. So it's a 36-month case on those three, so they're 12 months each consecutive. Mr. Taylor did serve, I think he said 27 months in
Yes,
prison. So that 21 SR 2672 is closed. They gave him credit for his probation time for his prison time. So what we're working with is the 21 SR 2673 and the 2675. He's got 340 days left on 2673 and then the full 12 left on the consecutive 2675. The fees have already been waived, and my understanding is that Ms. Matthews is going to convert the time that he served in prison, basically convert his fines to community service and wipe those for the time he served in prison. So what Mr. Taylor actually has left is $4,400 in restitution to 1888 Mills and $170 restitution for Sam's check cashing. The state, we have no problem with the fees being waived, the fines being converted. Our issue is the restitution. That's a significant amount of restitution that that's almost $4,600 in restitution. We want the restitution to get paid. We're fine with spreading that restitution over from not only the active case to the consecutive case and having them pay that in the biweekly installments, but we're not willing to waive that restitution because that's two victims that are out, especially 1888 Mills. I know it's a large company, but $4,400 is a significant amount of money. And then the 170 is Sam's check cashing also. So that's our position on it, that fines, fees, waive them, no problem, but he needs to get that restitution paid, and if he needs to spread it out now that he's working, if he needs to spread that out over the 2 years, essentially 2 years he has left, we can live with that. We just want that restitution paid.
Okay, that makes sense. All right, Director Matthews, filling in.
So pretty much everything that they said, Judge, Mr. Taylor came in immediately when he was released from prison. Most of the time, we can't get the people from the jail that were just in there 2 weeks ago to come see us. So to speak to Mr. Taylor coming in after serving a significant amount of time in prison, I mean, we didn't even have to track him down. He was there. So I just want to, recognize that he definitely did exactly what he needed to do. And it seems like he wants to try to take care of this. We do have him on biweekly because when we normally ask for about $500 a month, no one can pay that. So we do break it down into the biweekly payments, and that's just something pretty standard because it's a little bit easier to maintain. And an assistance to help Mr. Taylor, again, I've waived the fees. We're going to waive the court fines with the court's permission, but the $254 is solely just for the restitution. The way the orders are currently ordered is basically we're having to look at the whole amount, and we can only get him to do it in 12 months.
Oh, now I'm understanding the problem.
So if I could get an order that states that I can take both cases into consideration, then I could take that other 12 and break that payment down, is what we're here today to help Mr. Taylor.
Okay, and we have already corrected that on our new forms because our new forms say any unfulfilled, but he pled under the old forms. Now I'm understanding the problem. Okay, totally with you. Now, what you're asking for, I can only do if you tell me I can do it, because I'm not allowed to modify, I'm not allowed to change a secondary sentence without your express permission.
Yes,
So
sir.
do I have your permission to move the restitution payments throughout the entire set of your cases?
Yes, sir.
Okay, then I have his permission on the record, under oath. I'm doing this with his permission. I'm being very clear that I could not do this. Even if you said maybe, I couldn't do it. You're saying yes.
Yes, sir.
We're waiving the fees. The fines will convert to community service work and then apply that against his prison time, which should satisfy that altogether.
Yeah, that'll zero that out.
So that way I'll close that. So no more fines. We're waiving the supervision fees. You're just gonna pay your restitution, and this should lower the payments.
Yes, sir. Thank you.
This is a great solution. This is why I'm the luckiest judge in the state of Georgia, because I'm not very good at math, and they came in with a great solution. So, yes, sir.
With the community service, you can do it on Sundays?
You don't need to do it
You
at
don't
all.
have to do it.
Oh, okay, okay.
You've
Okay,
already
okay.
done it. What we did was we converted it and then applied it against your prison time.
Okay, thank you.
And I said that you did your community service work in prison. We don't often do that, but that's one of our tools we have in the very back of the toolbox that we'll pull out every now and then.
Okay, thank you.
And yours worked perfectly.
Thank you.
So you have one job, make your two victims whole.
Yeah.
That's it. You do that, you and I are gonna be just fine. You don't even have to pay them the monthly supervision fee. So we just want your victims whole.
All right, thank you.
So, all right, and you'll give me an order later, I
Yes.
guess. Okay. All right, and does he need to know his next report date or anything?
He's coming in on March 20th.
March 20th.
Yes, sir.
All right, this is a great solution. Thank you, Ms. Taylor.
Thank you, thank you.
You'll get a copy. They want me to go that way. Ever since that idiot jumped
Oh,
over the
yeah,
ditch
yeah,
in
yeah.
Vegas, they want me to have everybody go that way.
Thank you.
So, all right,
Have a nice day.
thank you.
You'd have to have some serious hops to get over that
I
one.
know.
You know,
I watched that video several times because I was very personally curious, and that was a very low bench. That was a security fail. So this bench, you'd have to like kind of throw your leg over and then roll over.
Yeah, I ain't got that one in me.
No,
I might
so-
get over Kathy's here, but I
That's
couldn't.
right. All right, we have one more case. It's our virtual from yesterday, Mr. Kleiner.
Did he have permission to record?
So I'm trying to figure that one out.
Was that?
Mr. Kleiner, I've sent you an unmute request. If you'll approve that, please. There you are. You there, Mr. Kleiner?
Yes, sir.
Perfect. All right, Mr. Kleiner, I'm gonna look you up in my system here. Give me just a second. I think you live out of the state. Is that correct, or am I confusing you with somebody else?
Yes, sir.
Where do you live?
Tampa, Florida.
Yeah, that's right. I knew there was somebody reporting yesterday.
Broward County.
Okay, so,
Here's what I'm willing to do with it.
okay.